You know those stories you hear about a deal that just feels wrong, where you can just tell someone is being completely taken advantage of? Well, it turns out the law actually has a name for that feeling: unconscionable conduct. And today, we're going to break down exactly what that means and figure out where the law draws the line on a deal being just too unfair.
So that's the big question, right? When does a tough negotiation, or maybe just a bad bargain, cross a line and become something legally wrong? Something so lopsided that a court needs to get involved. It's a problem the legal system has been wrestling with for a long, long time. And here's the really interesting part. To make sure the vulnerable are protected, the courts didn't just leave it up to a gut feeling. Nope. They created a very clear three-part test. This isn't about some vague sense of unfairness. It's a specific, step-by-step checklist, and we're about to walk through it right now.
So, here it is. The whole thing really boils down to these three key pillars. First, one person has to have what's called a special disability. Second, the stronger party has to have awareness of that disability. And third, they have to actually use that knowledge to get an unfair advantage. So let's break down what each of these really means.
All right, let's dive into that first pillar, special disability. Now, this is the absolute bedrock of the entire argument. Without this, the whole thing just falls apart. It means the situation has to start with one person at a serious, obvious disadvantage from the get-go. Okay, so what is a special disability? It's super important to get this right. It doesn't just mean a physical disability. It can be almost anything, like age, a lack of education, being in emotional distress, or even just not understanding the language well. It's any condition that seriously gets in the way of someone being able to look out for their own best interests. It's what creates that unequal playing field.
Okay, so we've got one person with a special disability, but is that enough? Does that automatically kill the deal? Not even close. And that brings us to the second pillar, awareness. This is where the spotlight shifts from the vulnerable person over to the stronger one. And this is absolutely crucial. It's not enough that the weakness exists. The stronger party had to have known about it. Or, it had to be so obvious they should have known. Think about it. It's one thing to sell a complex product to another expert, but it's a whole different ballgame to sell it to someone you know can't even read the contract. This is what separates a simple bad deal from actual deliberate exploitation.
And that leads us right to the final piece of this puzzle, Pillar 3, an unfair advantage. This is the action step. This is where the rubber meets the road. It's all about what the stronger party did with that knowledge of the other person's vulnerability. The law has a name for this: unfair procurement. It's when that stronger party actively, consciously uses their knowledge of the weakness to push for and lock in an unfair deal. They're leveraging that disadvantage, and that is the moment that a clear line has been crossed. Okay, let's put it all together now, because it's so important to see how these three pillars lock into place. This is what's known as a cumulative test. It's not a buffet where you can pick one or two. For a court to step in, you need the whole trifecta. So first, you have to prove that special disability. Think about an elderly person who's completely lost when it comes to digital contracts, or someone going through a messy divorce who's so emotionally distressed they just can't think straight. Second, you've got to prove awareness. The other person saw the vulnerability. They didn't just stumble into it. Imagine the salesperson who keeps up a high-pressure pitch even after a customer says, "Look, I honestly don't understand any of this." Yeah, they're aware. And finally, you have to show the unfair advantage. This is the payoff. That salesperson doesn't just stop to explain, they use the confusion to lock the person into a terrible interest rate. That is exploitation in action. And I really want to hammer this point home. All three of these elements must be proven. If just one of them is missing, say the stronger party truly had no idea about the disadvantage, or the deal itself was actually pretty fair, then the claim of unconscionable conduct is going to fail. It's a high bar to clear, and for very good reason. So when you boil it all down, what's this all for? Well, this legal principle isn't some get-out-of-jail-free card for a deal you just regret later. It's a legal shield, forged specifically to protect the most vulnerable people in our society from being preyed upon when making agreements. And for all you history buffs out there wondering where this all came from, a lot of the modern rules were laid out in a landmark Australian case back in 1983 called Commercial Bank of Australia versus Amadio. It's a pretty powerful story involving elderly immigrant parents, their son's failing business, and a bank. And it basically set the gold standard that courts still follow today. So I'll leave you with this question to think about. Now that you know the three pillars, disability, awareness, and advantage,
Where do you personally draw the line between just a hard-nosed, tough negotiation and actual unfair exploitation? The answer isn't always so clear-cut, which is exactly why this legal shield is so incredibly important.